No, but we must state on our appeal. We must state on our appeal. But when was the judgment? When was the judgment?
The judgment was on the 22nd.
Saka, which judgment are we dealing with on appeal? Are we dealing with the judgment of the 22nd? Are we dealing with the judgment of the 1st? Are we dealing
It was, the judgment was fast, but the corrected, remember, mistakes was on the 4th. Saka, the final was the 4th. It's not a mistake.
We have to clarify
If it pleases this honorable court, my lord and learned assessors, to hear the matter of state versus Moses Mpofu and Mike Chimombe.
Very well. This is the sentencing judgment in the case of the state versus Moses Mpofu and Mike Chimombe. The accused persons were arraigned before us for a joint trial charged with fraud, as defined in Section 136 of the Criminal Law Codification and Reform Act, Chapter 19.23. Hereinafter, the Act will be referred to as the Criminal Code. The trial had been set to start on the 1st of August 2024, but several legal issues came up which the accused person wanted determined by the judge before the actual trial could start. The trial eventually commenced after 9 months on the 27th of May 2027 and was so fiercely contested that it took a year to complete. At the conclusion of the trial, we convicted the accused persons as co-perpetrators of the crime charged, as provided for in Section 196A of the Criminal Law Code. The first offender is Moses Mpofu, a male adult aged 50 years. He is married with 9 children who are dependent on him, and they are aged between 6 years and 25 years. 8 of the children are still in school, and out of the 8 children still going to school, 1 is doing tertiary education. He is employed by Blackdick Private Limited as his director and earns a salary of between $10,000 and $15,000 United States dollars. The second offender is Mike Chimombe, a male adult aged 44 years. He is married to 3 wives and has many children dependent on him. He is involved in farming and other business ventures. He is the director of Militech Private Limited. His earnings range between $15,000 and $20,000 United States dollars. He has a residential property in Borodale worth $800,000 and another in Chinoy valued at $120,000 United States dollars. The background facts are that in the year 2021, the government of Zimbabwe set up a presidential goat person scheme to alleviate poverty among the less privileged citizens across the country in the 10 provinces. The target was to buy about 500,000 special goat breeds for distribution to households throughout Zimbabwe. In the scheme, which was administered by the Ministry of Lands, Agriculture, Water, Fisheries and Rural Development. We refer to the ministry as just the ministry. The ministry advertised a tender on the 3rd of September 2021, inviting companies which met the set mandatory requirements for eligibility to submit bids for the supply and delivery of goods. A standard bidding template was published with a tender setting out the eligibility and qualification criteria to be met by interested companies. And these were pursuant to the provisions of Section 28 of the Public Procurement and Disposal of Public Assets Act, Chapter 22.23, as read with the Public Procurement and Disposal of Public Assets General Regulations of 2018. That is Statutory Instrument 5 of 2018. The participating bidders were required to meet these requirements, which included specific ethical standards, the legal capacity to enter into a procurement contract, not to be insolvent or to be under judicial management, and they were supposed to have paid all taxes, duties, and rates for which they were liable in Zimbabwe, and contributions and payments due to the National Social Authority National Social Security Authority, and that their officers ought not to have been recently convicted of any offense related to to their professional conduct, or to have made false statements or misrepresentations as to their qualifications. The accused persons both pleaded not guilty, and as I have said, their conviction followed a contested trial. We found, at the conclusion of the trial, we found the two accused persons guilty as charged as co-perpetrators of the crime. Just for completeness, an actual perpetrator in relation to any crime is defined in the Criminal Law Code as a person who, with the requisite state of mind, actually does, completes to do all the acts which constitute that crime. However, in terms of Section 196A of the Criminal Law Code, accused persons or persons are criminally liable for conviction as co-perpetrators if the state proves that they committed the crime in association with each other, and the state adduces evidence to show that each of them had the requisite mens rea to commit the crime. Those are the two requirements. The intention arises from having the intention to commit the crime, or the knowledge that it would be committed, or the realization of the real risk or possibility that the crime in question would be committed. Where the state proves that the accused persons did the acts in association which constitute crime in association with other, and that each of them had the requisite mens rea to commit the crime, the accused persons are then convicted as co-perpetrators, in which event the conduct of the actual perpetrator, even if none of them is identified as the actual perpetrator, shall be deemed to be the conduct of every other co-perpetrator, whether the conduct contributed directly in any way to the commission of the crime or not. There are certain circumstances that are regarded to be indicative of association in committing crime. These include the presence at or in the vicinity of the crime in circumstances which implicate them directly or indirectly in the commission of the crime. Another indicator would be association together in end conduct that is preparatory to the conduct which resulted in the crime. Another indicator would be engaging in criminal behavior as a team or a group prior to the conduct which resulted in the crime for which they are charged. These are not necessarily the only decisive indicators or decisive factors, but the law prescribes these as some of the indicators. For the purposes of explaining and making clear the respective participation, we are required to just give a brief, very brief summary of the evidence adduced by the state from the witnesses. The conviction of the accused person followed our finding that the witnesses were credible and we believed their evidence. Just briefly, Bevan Mtsikamawe, who is employed by the Ministry of Justice under the company's deeds and intellectual properties as a principal examiner, testified that from February 2020, a company could do business under an assumed name But before using the assumed name, the company was required to register the name in terms of Section 29 of the Companies and Other Business Entities Act. He said Black Deck Private Limited was a company incorporated in terms of the Act, but he said Black Deck Livestock Poultry Farming was not registered as the name of any company on incorporation or an assumed name of any company registered in Zimbabwe, Black Deck Private Limited included. Fungai Kafunde, employed by Zimra as a supervisor, testified that the tax clearance certificate used by the accused person in this case purported to be a genuine tax clearance certificate issued to Black Deck Private Limited. It, however, turned out to be a counterfeit because the QR and verification codes showed that in fact the certificate belonged to Skywalk Investments and it had been altered by superimposing the name Black Deck Private Limited. He also testified that a company which is tax compliant can easily obtain and print a tax clearance certificate from the Zimra self-service portal. Taito Mbambi told the court that he's employed by NASA as a compliance manager. He said a NASA compliance certificate is issued to companies which are in compliance with NASA statutory requirements. And a NASA compliance certificate is a mandatory requirement in government tender processes. All government ministries, departments, and agencies are instructed to include a NASA compliance certificate among other mandatory documents required for eligibility to tender for government contracts. He also said that a company which is NASA compliant can generate a NASA compliance certificate from a NASA self-service portal. He was aware that Black Deck Private Limited as a company was previously registered but was deregistered in 8 January 2016 and had been inactive ever since. The certificate used by the accused persons, when scanned on its QR code, gave out the name of Skywalk Investments and not Black Deck Private Limited, which appeared on the face of it. He said for that reason, the certificate was a counterfeit. In any event, according to him, Black Deck Private Limited was not NASA compliant and was not eligible. The import of the evidence of these witnesses was that there was no need really to outsource the procurement of these documents that turned out to be counterfeits. John Basera's evidence is summarized, but it's a bit slightly longer in the sense that it goes on to deal with the respective participation of the accused persons. He said that he was the permanent secretary in 2021. He confirmed the advertisement of the bid and the presidential goat person scheme. He explained that the tender was part of a government rural development program meant to uplift livelihoods of rural families in areas with low rainfall and areas where livestock was affected by disease, a disease called the January disease, during the period extending from 2015 to 2020. It was therefore the purpose of this program to raise about 500,000 goats, which were then to be distributed. Each household was going to get one goat to boost household nutrition and financial security. And bidders were required to supply mandatory documents which were indicated in the template provided by the ministry. He confirmed the issue of the certificates that we have already referred to. He said the original contract price was 87 million, which was then eventually spread over a period of 5 years. However, as accounting officer, he realized that there would be no value for money when considering the individual prices of the goats. The initial price was $175 to $250 United States dollars, which he, as accounting officer, considered exorbitant. In light of that, the ministry further negotiated the prices, and which came down to United States $75 to $92. According to him, the prices included the purchase of the goods, if the goods were to be purchased, mobilization costs to the holding pens, and onward distribution to faraway villages. He said then later they realized that there was no satisfactory progress made by Black Tech in fulfillment of this contract, whereupon a number of meetings were held, and eventually the bidder wrote a letter saying that it had raised 32,500 goats in holding pens pending distribution. The ministry embarked on a verification by dispatching teams to the various centers which had been told by the bidder, and only 3,388 goats and 325 kids were found out of the 32,500 goats which were expected. He said, in light of the advance payment which had been made, which was equivalent to $7,712,197 United States dollars, at the average price of $90, the ministry had expected to find 85,000 goats, and there was therefore a huge shortfall, which translated to 89.6%. As far as the involvement of the accused persons, the two accused persons is involved, he said, in chasing up the performance, the ministry dealt with the first and second accused persons. It appeared that the first accused person was the operations manager, and the second accused person would be present at all the meetings which the witnesses convened pertaining to the presidential God-person scheme. The second accused person appeared to him, in his observation, to be the most senior because he assumed a leading role during the deliberations and appeared to be the ultimate decision maker. He said the government suffered actual prejudice. In his evidence, he kept referring to the bidder as Black Tech. He maintained that natural persons who were behind the bid or any bid submitted to supply goods were not allowed to interact with the ministry officials before the award of the tender. Due process demanded that all bids were supposed to be determined on the papers. The people behind the bid would only be known after due process had taken place on the papers and the tender awarded. He said by due process he meant the various stages on the papers to ensure compliance with the Public Procurement and Disposal of Public Assets Act. He, however, said that that did not mean that the ministry officials did a good job, because as it turned out, this fraudulent bid sailed through. He said he knew the second accused person prior to interacting with him in connection with this case as a political figure. He had not met the second accused before the award, but he met him afterwards. And that was natural, that was proper according to him, because he was not expected to meet anyone anyway prior to the award of the bid. Face-to-face meetings would be held afterwards. He said the second accused person was among the Black Deck officials, or the people that he considered to be Black Deck officials during the negotiations and at the launch of the scheme in Chipinge. He said his observation was that the second accused person had a physical connection with Black Deck. He said in his observation was that the second accused person was personally involved in interacting or in the interactions between Black Deck and the ministry. He maintained that he knew the second accused person and he had interacted with him. Isa Precious Issa, told the court that she's employed by the Minister of Agriculture in the procurement unit. She handled the tender bids submitted in response to the advertised tender. She confirmed that she drafted the contract between Black Deck Livestock and Poultry Farming and the government of Zimbabwe. She was of the view that Black Deck Private Limited, Black Deck Livestock, Poultry and Farming, and Colenso Farms were names which all referred to the same entity, which all lawfully referred to the same entity. And she said, for that reason, she prepared the contract wherein she made Black Deck Livestock and Poultry Farming a party. Chennai Garise Neta, who is a lawyer in the ministry, said she was the chairperson of the evaluation committee which adjudicated on the bids submitted in response to the presidential pass-on scheme. She did not know the accused persons. She said her committee checked the bids for compliance. However, the committee did not do any due diligence, and they dealt with the documentation submitted in support of the bids, and particularly the bid submitted by Black Deck Livestock and Poultry at face value. According to her, the documents submitted appeared genuine on the face of it. The ZIMRA tax clearance and the NASA compliance certificate appeared genuine at face value. The logos were convincing. The names of the issuers and so on the form looked exactly like the other ZIMRA and NASA certificates they had dealt with regularly. She was, however, of the opinion that had the fact that the certificates, the ZIMRA and NASA certificates, which were submitted were counterfeits, then the misrepresentation would have resulted in the contract which ensued being null and void. She said, at the time of giving evidence in the year 2025, Black Deck had not submitted any valid tax clearance or any NASA compliance certificate to replace the counterfeits. Alban Mindurwa his evidence was a bit longer, but we also summarized it. We said that he is employed in the ministry as the director of livestock, and when the tender for the presidential goat scheme was advertised, the first accused person visited his office inquiring about the tender. Prior to its award, he directed him to the relevant department. He exchanged numbers with the first accused person. Later, when he heard that the goats were coming, he inquired from the accused person through the phone about the tender, and the first accused confirmed that he had won the tender. Whereupon he congratulated him. Subsequently, they met, and in March, the two accused persons came to his office, and he discussed with them the mobilization of the goats, and that he told them that he was working on the distribution modalities. He said thereafter he would receive updates from the accused persons regarding progress in mobilizing goats. He later received information, or rather a letter was copied to him. The letter was addressed to Obed Jiri, the chief director then in the ministry, that 32,500 goats had been mobilized. The permanent secretary demanded a verification exercise, and the verification, and he then invited the first accused person to attend a meeting in his office to discuss the modalities of the verification exercise. He said the first accused person arrived at the office accompanied by the second accused person. It is common cause, rather it is not disputed in this trial, that the second accused person attended the pre-departure meeting, which was held to discuss the modalities of the verification exercise. The second accused person, however, had his own explanation for attending the meeting, but he did not dispute that it was a pre-departure meeting held for the purposes of discussing the verification modalities. In December 2022, he produced the goats performance report, and at that stage, 4,208 goats had been supplied, valued at $331,445. And out of the money that had been paid by the ministry, a sum of 7.38 million remained unaccounted for. He continued to engage the accused persons, asking them to supply goods as they were urgently required in the distribution centers. Obed Jiri also testified. He said initially in his evidence in chief, both accused persons were involved in deliberations when the prices were discussed, and they were representing Black Tech. He was referring to the accused persons by their names. Each time he referred to the first and second accused person, he would refer to them by their names. He said, under cross-examination, he said he didn't quite remember the number of times that he had interacted with the second accused person particularly, because initially he was new, but as time went by, the two of them became acquainted with each other. He said he observed the second accused person at the lounge in Chimombe, and according to his observation, the second accused person was associating with the delivery of the goats by the bidder. The last witness was Spiwe Mpadzula, an employee of CAPS who produced the bank statements belonging to Blacktech Private Limited and Militech Investments. They showed the money which was paid by Treasury into a Blacktech account, Blacktech Private Limited CAPS account, and that out of that 200 million was then moved to the Militech Enterprises Private Limited bank account. Militech Private Limited is a duly registered company, and the second accused person is its director. There are other directors, of course, but he's one of them. We were satisfied after hearing this evidence, and which was the basis for the conviction, that indeed a fraud was committed. That the fraud was committed as follows. A bid was submitted in the name of a non-existent company, which was named Blacktech Livestock and Poultry Farming. And it purported that the company was duly incorporated in terms of the laws of Zimbabwe and had the capacity to act. But to give it the semblance of a registered company, the non-existent company or the fictitious company was clothed with the credentials of a duly registered company known as Blacktech Private Limited, and which we described in our judgment as a case of stolen corporate identity. And we said that explains why the ministry officials referred to the bidder as Blacktech, interchangeably as Blacktech, sometimes as Blacktech Private Limited, sometimes as Blacktech Livestock and Poultry, and sometimes as just Blacktech Livestock. We were also satisfied that the fraud was also committed through the submission of counterfeit tax clearance certificates, which initially belonged to Skywalk, but had been altered to appear as if they had been issued to Blacktech Private Limited. We said that to give Blacktech Livestock and Poultry Farming the semblance of a legal persona, corporate documents belonging to Blacktech Private Limited were used, and clearly because the name of the fictitious company, or the name which had been chosen, used for the fictitious company, was very close to the name of Blacktech Private Limited. But as it turned out, Blacktech Private Limited did not have all the documents that were required. A tax clearance certificate and a tax compliance certificate was required, and naturally, Skywalk Private Limited was clearly different from Blacktech Private Limited, and its genuine certificates had to be altered, and the name Blacktech Private Limited superimposed, so that they would be submitted together with other documents belonging to Blacktech Private Limited. We noted that the fraud was successful in that the fraudulent bid sailed through the verification processes, the adjudication processes, and actually, when submitted the Procurement Regulatory Authority of Zimbabwe, it did endorse recommendations by the ministry to award portions of it to the successful bidders. We convicted the accused persons as co-perpetrators, but among the undisputed facts which related the first accused person were that he admitted that he was among the people who conceived the idea to submit this bid to supply goats under the presidential goat scheme. He said he was aware that Black Duck Livestock and Poultry Farming is not a registered company, although he said that he believed that a registered company could lawfully use that name. But the law as obtaining at the time of submitting the bids was not contested. This is part of the main judgment. He was aware that Black Duck Livestock Poultry Farming, not being a registered company, lacked the capacity to act. As a board member of Black Duck Livestock, Black Duck Private Limited, whose legal documents were used, he knew that the documents had been used in support of the bid.
If it pleases this Honorable Court, my Lord and learned assessors, to continue hearing the matter of State versus Moses Mpofu and Chimombe.
Very well. I will start from what is now the second paragraph at page 10 of the sentencing judgment. But just in case the pages move, it is the paragraph which commences with the words, "The circumstances of this case, in as far as they are relevant to the second accused person, are as follows." Rather, I should go back to page 9 and just reread the respective participations of the accused person. The undisputed facts in as far as the first accused person is concerned are as follows. He was among the people who conceived the idea to bid for the supply and delivery of goods under the Presidential Goods Pass-On Scheme, and he associated himself with the use of the fictitious company, Black Duck Livestock and Poultry Farming. He said this name was used deliberately and intentionally. He was aware that Black Duck Livestock and Poultry Farming was not a registered company. He was also aware that for that reason it lacked capacity to act. As a board member of Black Duck Private Limited, he was aware that legal documents of incorporation belonging to the company had been submitted in support of the fraudulent bid. And he was aware that the result would be that the fictitious company was then unlawfully clothed with the corporate identity of Black Duck Private Limited. He considered that the ZIMRA and NASA tax clearance certificates, which were among the mandatory requirements for eligibility and were submitted by Black Duck Livestock and Poultry Farming, were counterfeit. He was aware that such certificates were required, and he was aware that certificates had been submitted. He accepted that as a lawful director of Black Duck Private Limited, he was in control of his business affairs. He also admitted attending several meetings with the ministry officials where the terms of the contract eventually signed between the government of Zimbabwe and the fictitious company were discussed and agreed upon. He admitted signing the contract on behalf of the fictitious company. Or he agreed to sign the contract on behalf of Black Duck Livestock and Poultry Farming, which turned out to be a fictitious company, put in different words. He was also its representative in the performance of the alleged contract. He did not dispute that Black Duck Livestock and Poultry Farming did not have a bank account. It is a fact that it could not open a bank account because it had no capacity to act. As a result, payments could only be received through the bank account of Black Duck Private Limited at CAPS. It is correct that the bank details of Black Duck Private Limited were supplied in the purported contract, which was purportedly entered into between the government of Zimbabwe and Black Duck Livestock and Poultry Farming, which turned out to be a fictitious company. It is throughout the trial, the first accused person maintained that the bulk of the money received from the ministry was traded on the foreign currency black market. The circumstances of this case, in as far as they relate to the actual conduct of the second accused person, are that the state-led evidence from witnesses, which I've already referred to, that he appeared at the ministry and to represent Black Deck in the meetings that were referred to by the witnesses. The evidence of the witnesses whom we believed showed his participation and his association with the fictitious company. The witnesses said that by and large the accused persons, or rather the second accused person, would appear at these meetings in company of the first accused person. They said that he conducted himself in a manner which gave the impression that the second accused person and the first accused person were the faces of the company that they thought they were dealing with. The second accused person admits or admitted attending the meeting convened by Alban Mindulwa as a pre-departure meeting for the God's verification exercise. He agreed that he attended that meeting in the interests of the bidder, which we all know now was a fictitious company. At that meeting, he also said that he was attending in his capacity as the chairperson of the Economic Empowerment Group in Zimbabwe, which lobbies for preferential treatment of indigenous companies in government procurement contracts. He, however, notwithstanding his assertion that he was representing the interests of the bidder, did not produce any resolution which authorized him to appear. He's a director of a company and he knows how companies act. He knows that companies act by way of resolution. He did not have a resolution from the Economic Empowerment Group to represent it. The inference that we drew from that was that he was attempting to advance his personal interests and that his association with the fictitious company. We have already referred to the liability of co-perpetrators. In 196, the persons charged together are both actual perpetrators and co-perpetrators. They are the actual perpetrators with respect to the roles that they played in the acts that constituted the criminal conduct giving rise to the fraud. But they are also liable for the acts committed by their co-perpetrators, which were within the common design. The fact that he was appearing and ostensibly on behalf of the bidder means that he clearly associated himself with the fictitious bidder. In the inference which we withdrew, as in the main judgment, was that in all the circumstances of this case, he associated himself with the grand plan to misrepresent the fictitious company which submitted the bid as a registered company. At all times, the ministry officials believed that they were dealing with him on behalf of a lawfully registered company. He was also seen at the launch. He has got his own explanation, which we rejected. He said that he attended there in his capacity as a politician, and that as a member of the public. But we observed in the main judgment that at the launch there were two parties main to the launch. The one party was the party which was associated with the delivery of goods, and the other was the government which was receiving the goods. The witnesses made the observation that he was clearly associating himself with the delivery of the goods, and purportedly by the fictitious company. We also found that he is a director of Militech Investments, which received 200 million out of the proceeds of the crime. And as director of Militech, he was controlling its affairs and is criminally liable for unlawful receipt of these proceeds. The money was unlawfully traded on the black market, and clearly, as director, he must have been party to the decision, and in fact he doesn't deny that, to trade the money on the black market unlawfully. The company, Militech Enterprises, was fined by the Reserve Bank, as well as Black Tech Private Limited and the other entities that received the money. The modus operandi in terms of the manner in which the money was used after hitting the accounts of Black Tech Private Limited and Militech was essentially the same. No record was kept of the money that, of how that money was traded on the black market. No record was kept, or at the very least produced in this court, of how the money was used. It was not banked, notwithstanding the requirements of the Bank Use Promotion Act. We convicted him on the basis that, among other things, the circumstantial evidence in this case, the conscience of it, from the plethora of the independent circumstances that we have outlined above, all pointed to the same conclusion, that he was part of the unlawful project with the requisite mens rea to commit the crime of fraud. We therefore found him guilty as a perpetrator, as a co-perpetrator. And we said the totality of the circumstances could not be explained on the basis of any other inference other than that he was a perpetrator. Now, the law regarding the sentence is as follows. In terms of Section 136 of the Criminal Code, any person found guilty of fraud is liable to be sentenced to either pay a fine not exceeding level 14 or not exceeding twice the value of any property obtained by him or her as a result of the crime, whichever is greater. In other words, it is possible for an accused person to be sentenced, the accused person convicted of fraud to be sentenced to a fine which is equivalent to 2 times his or her share of the proceeds. Or the accused may be sentenced to imprisonment not exceeding 35 years. The legal practitioners representing the accused persons and the state did not motivate the first option, that is that of imposing a fine which is equivalent to the accused person's share of the proceeds. I'm sure the decision was guided by the provision of the sentencing guidelines, or rather the criminal procedure sentencing guidelines regulations of 2023, which is statutory instrument 146 of 2023. The guidelines were promulgated in the year 2023 pursuant to the provisions of section 334A of the Criminal Procedure and Evidence Act, chapter 907, which empowers the Judicial Service Commission from time to time to convene a judicial conference for the purposes of formulating sentencing guidelines, which in particular provide for inquiries and investigations to be conducted by courts prior to sentencing for offenders, factors to be considered by the courts when sentencing offenders, the forms of punishment that may be imposed as alternatives to custodial sentences, and the principles and criteria which will assist in promoting consistency in sentencing and equitable sentencing. And section 334A in brackets 1 of the Criminal Procedure and Evidence Act further provides that the sentencing guidelines shall be in the form of a table of presumptive penalties supplemented by other additional guidelines addressing such factors as the Judicial Conference considers relevant. And the sentencing guidelines apply to all criminal proceedings in all courts which conduct trials at first instance. And of course the appellate courts as well, they take that into account in reviewing the work of the lower courts. The object of the sentencing guidelines is to foster public confidence in the criminal justice system by, as I said, promoting consistency and promoting transformative justice in sentencing and eliminating unwarranted disparities in punishment of offenders. With that in mind, the sentencing guidelines were widely circulated. Meetings were held throughout the country where the sentencing guidelines were explained. It is therefore, the whole idea was to inform the public and to make people aware of the likely penalties in the event that they commit crime, thereby achieving deterrence. As a result, presumptive penalties are largely known. They are largely public knowledge. The sentencing guidelines are binding on the court or on the sentencing court. Previously, the court was at large, but of course guided by existing principles and guidelines of decided cases. What the guidelines have done largely was to collect all principles that have come up from decided cases and to put them in one compendium which is easily accessible, and of course explain them and explain how they work. What is important to note is that where a presumptive penalty is prescribed, a sentencing court may depart from it, but it must give reasons for the departure. That, of course, was also aimed at promoting consistency. All courts are expected to have a starting point somewhere and then exercise their discretion in either imposing a sentence below the presumptive penalty and give reasons for it, or impose a sentence above the presumptive penalty up to the maximum provided in the penal provision, in this case 35 years, and give reasons for it. A presumptive penalty is described in the sentencing guidelines as a penalty expressed as a specific amount of fine or a specific period of imprisonment, or both, that is midway between an augmented penalty which may be imposed in aggravating circumstances and a diminished penalty which may be imposed in mitigating circumstances. That is why it is a starting point, but which must be respected, which should be followed, and a court which departs from it must give adequate and satisfactory reasons for doing so. Now, from the definition of a presumptive penalty, it then becomes clear that in every case, the sentencing guidelines provide for 2 presumptive penalties with respect to each crime. Now, in the case of fraud, the offense for which the accused persons have been committed, a fraud is deemed to have been committed in aggravating circumstances if one or more of the following situations obtain. If the items or funds or property involved were of considerable value, the offense is considered to have been committed in aggravating circumstances. If the funds, like in this case, were not recovered, the offense is said to have been committed in aggravating circumstances. If the offender was in a position of trust, which according to the state applies, and according to the defense did not apply in this case, because they were not really holding the funds in trust, and we will give the accused persons the benefit of that. And if the offender was a holder of public office, which does not apply. But if the offense involved public funds, the fraud is deemed or is considered to have been committed in aggravating circumstances. So when, as I said, when these aggravating circumstances exist, the law provides for a presumptive penalty of 20 years. The other presumptive penalty is when is a diminished punishment prescribed for offenses committed under mitigating circumstances. The mitigating circumstances are listed in as far as determining which the presumptive penalty to begin from, as where potential and actual prejudice was insignificant, or that the offender voluntarily compensated the victim. In that case, the presumptive penalty is prescribed as 6 months, and the court may go up or down, or even impose a fine in appropriate cases if the circumstances of the case demand it, particularly if the mitigating circumstances are compelling. The case before us involves prejudice in the region, potential prejudice in the region of 87 rather 26 million US, about 26 million, which is being 30% deposit of the contract price, which was pegged at 87,757,168 United States dollars at the rate prevailing on the day. This is the amount that the government had initially agreed to pay for the goods required in terms of the presidential scheme. Treasury only managed to disburse 1.6 billion in Zimbabwe dollars, which, it is not disputed, was equivalent to $7,712,197, rather, $7,712,197.10 United States dollars. This was because, as explained by the Permanent Secretary, due to financial constraints. We therefore find that the potential prejudice, the amount that could have been disbursed as 30% of the deposit, being the potential prejudice, was high, and the actual amount that was disbursed was also considerably high. So, to that extent, the offense was committed in aggravating circumstances. The bulk of the money was not recovered, as explained above, And for that reason, the offense was committed under aggravating circumstances. There was no voluntary reimbursement of the money, which essentially cancels one of the mitigatory circumstances they are provided in the table in determining the presumptive penalty to start from. And it is common cause that this money was disbursed by its treasury. It was therefore public funds, and to that extent the offense was committed under aggravating circumstances. Therefore, the unescapable conclusion is that the presumptive penalty to start from is the penalty of imprisonment for 20 years. The first accused person gave evidence in mitigation. Largely, we have referred to his personal circumstances. And he also said that he has properties. But by and large, he dwelled at length on what he said was the performance of the contract. The performance of the contract, Mr. Koto produced a sheet of paper, a piece of paper, which was on the letterhead of Black Deck Private Limited. Which was on the letterhead of Black Deck Livestock and Poultry Farming, but with a logo bearing the name Black Deck Private Limited, and which purported to list how the expenses or how the money that was disbursed by the ministry into the Black Deck Private Limited CAPS account was disbursed. It was largely disbursed, yes, to certain companies under the pretext that the companies had been recruited as agents to supply goods, and it was some of it was disbursed to the lawyers who were representing the company during the performance or issues to do with this bid. But the bulk of the company, the money, according to that piece of paper, was disbursed in improving infrastructure at Colenso Farm. The issue that arose is the weight to be attached to that paper, because it was not signed, it was not clear. In fact, it didn't say. It didn't speak for itself regarding who had prepared that document and when. And in fact, the first accused person had throughout the trial been steadfast, refused to account for this money. And this came in mitigation. And in the problem is that it was inconsistent with this position taken by the first accused person, that the bulk of money during the trial, that the bulk of the money was traded on the black market to buy United States dollars. The state submitted that, in fact, if the money was used to develop the infrastructure at Colenso Farm, then it was clearly misappropriated, because that was not the purpose for which the money was dispersed. We are surprised that at this stage of the trial, Mr. Koto persisted with the argument that a contract came into existence. The view we take is that because the ministry disbursed money pursuant to a fraud, then all the monies that were disbursed pursuant to that misrepresentation was process of crime. There is no need to talk about a contract. Mr. Koto is a lawyer. He knows too well that only parties with capacity to act can enter into a valid contract. Black livestock and poultry farming lacked the capacity to act, and it could not possibly be a party to a valid and binding contract. Mr. Koto also submitted that the state has got a title deed for a property in the accused's name, but he did not go further to say why he was making that submission. We thought that he was making that submission to offer compensation, but he fell short of saying that, and which underscores the fact that there was no voluntary offer to compensate. In mitigation, the first accused person considered that public funds were involved. Under cross-examination by the state, the first accused person eventually considered that fraudulent documents had been used to secure this contract, to secure the tender, and he apologized to the head of state and to the people of Zimbabwe at large. Although coming very late at these criminal proceedings, it's still an apology. An accused person who believes in his innocence is entitled to defend himself, and it is also expected that when he realizes that he was wrong in denying the charge, he must still be given credit for acknowledging wrongdoing and extending an apology for doing so. He will therefore benefit for having apologized to the head of state and the nation at large. Mr. Koto gave us other cases, some cases which I don't need to repeat in this extempore judgment, but they will certainly be part of the written judgment in order to assist us in arriving at the appropriate silence. Mr. Koto submitted in mitigation that there is no reason for the first accused person to be made to suffer on his own, or perhaps with the second accused person, for this offense, because the state deliberately abstained from charging the other co-perpetrators. He did not mention, but clearly it was clear that he was referring to the other directors of Black Tech Private Limited. They are Ajne Kabisira, who clearly took part by submitting the bid. It is on record that she's the one who signed, who put a signature in the book where the names of the persons who were submitting bids on behalf of companies were being recorded. Her name appears in that. Very well. That may affect other things, perhaps restitution, but it doesn't affect his moral blameworthiness. It will certainly be taken into account when we come to restitution. He was probably referring to Tinashe Chimombe, whom we now know was a de facto director of Black Tech Private Limited, the company which lent his credentials to the fictitious company in order to give the fictitious company the semblance of a registered company. We totally understand why Tinashe Chimombe was not charged by the state. His involvement only became known during the proceedings, and so from the circumstances of this matter, it is safe to conclude that he was not charged because the state was not quite aware of his involvement as a director of the company which lent his corporate credentials to the fictitious company. But his involvement, having been brought to our attention, will be taken into account at the right time. But the state has got the prerogative to decide, as we said in the judgment, who to charge and who not to charge. There are several considerations that the prosecutor general takes into account. They are not known. This court is not privy to them. But what this court is privy to are the current considerations, because those are published in terms of the Constitution. The prosecutor general considers the sufficiency of evidence and policy considerations. Policy considerations are up to the prosecutor general. So we don't know why Ajene Kabisa was not prosecuted. We always respect the prerogative of the prosecutor general, and we don't wish to be invited by Mr. Konto to comment on that. It would be literally interfering with the constitutional independence of the prosecutor general. The second accused person also submitted in mitigation. He did not give evidence, but submissions were made on his behalf by his legal practitioners. That is perfectly acceptable, and by and large, we have recounted his personal circumstances at the beginning of this sentencing judgment. Mr. Mugia, who submitted first, gave us cases which we found very useful, and I don't have to go through them now because they appear in the sentencing judgment. But most importantly, he said that he said that the sentencing guidelines apply to this case. He urged us to be guided by the sentencing guidelines. We accept that submission. That is correct, because the sentencing guidelines speak for themselves. They say that they are binding on all sentencing judicial officers and courts. Mr. Mugia submitted that the second accused person is a first offender. I omitted to mention that as well with respect to the first accused person. That is admitted. In our law, I will come to the sentencing guidelines. That is a very important factor. He indicated that there was no possibility of reoffending. He undertook, he submitted that he had the authority to undertake on behalf of his client that the accused person is not likely to reoffend. Having been in custody since June 2024, he has learned the lesson well from the lengthy pre-trial detention. He's already deterred, I believe, and this submission was based on the fact that he was accepting, as is required by law, to mitigate, on the basis that one is required to mitigate on the basis that they've been convicted. Not necessarily that they are happy about the conviction, but because that is the law. They are bound by the conviction. So he said the conviction as it is a big lesson to him. He's already been in custody for a lengthy period, and that has been a lesson. Mr. Mugia gave us background of the offender. he said described as a traditional man who grew up in the rural setup and is a typical rags to riches person, and who is largely unsophisticated, but he worked very hard for the station that he now occupies in life. He submitted that the second accused person did not premeditate this offense. I've already referred to his earnings, and Mr. Mugia said they are title deeds for the properties that we described at the beginning of this judgment. He, however, fell short of submitting that the accused person was willing to sell those properties to compensate Treasury. But we assume that is the reason why he was making that submission. But importantly, which is an important factor, Mr. Mugia submitted that the second accused person suffers from chronic illnesses which require constant medication. The chronic illness is hypertension, commonly referred to as BP, and that has required him to visit South Africa at least twice a year. He said that in the event that he's sentenced to imprisonment, he will not be able to actually travel to South Africa to receive the specialist treatment. Obviously, this was submitted with respect to to persuade this court to impose a sentence which may be below the presumptive penalty or not too far above the presumptive penalty, to be lenient in the sentence that we were imposing, because incarceration, he said, will adversely affect or negatively affect his health. This is an important factor which is always taken into account by a sentencing court. People are not sent to prison so that they may then have their health conditions deteriorate. But he, however, did not submit that treatment for hypertension is not available in Zimbabwe. He was traveling to South Africa because he could afford it, but there's no suggestion that treatment for hypertension is not available in Zimbabwe. This is critically important because the chronic ailment was disclosed as hypertension. Mr. Mugia submitted that the second accused person played a minor role in this offense. The state does not accept that, but we will come to that. However, for the purposes of conviction, clearly, as I've already explained, the role played by co-perpetrator does not really matter that much as long as his conduct was within the common design. But he's correct. When it comes to sentencing, the role of each co-perpetrator becomes very significant, and the court is at large to distinguish in sentencing between co-perpetrators, at least in that regard. The understanding is that co-perpetrators are liable to the same penalty, but the court, in the exercise of its discretion, is entitled to distinguish if there are circumstances justifying distinguishing. And that is the point that Mr. Mugia was making, and we accept that as a valid point in mitigation. He said, by and large, the second accused person, together with the first accused persons, are good citizens. They have offended for the first time, but they have shown that they respect the law, because when this offense, or when Zach publicized that it was looking for them, they came and presented themselves to Zach. I'm sure this was meant submitted for the purpose of demonstrating that in this particular case, emphasis should be on rehabilitation. You are starting from the premise that they are law-abiding citizens. We have transgressed, and they can be rehabilitated. He admitted that yes, the offense is serious. Yes, public funds are involved. Yes, there was no restitution. He acknowledged that. We respect him for that. But he said they cannot really be considered to have been in a position of trust because they are not public officials. We have already said that we will give them that benefit. Mr. Maduku weighed in with the law, particularly the implications of the sentencing guidelines and the implications of Section 196A. He explained to us that he accepts that within Section 196, you have got party people who are associating with each other in committing a crime. But it must be accepted that in the process of associating with each other with the same intention to commit the crime, they may play different roles. That is implicit in Section 196A. So when it comes to sentencing, yes, they are both liable for the same penalty, but there's room for the court to exercise discretion and distinguish between them. We accept that argument. He then said, this court does not really need to visit all the punishment for this offense on the accused persons. I hope I'm quoting right. But he says there was contributory culpability on the part of the victims. The state officials which handled this tender were grossly negligent. Because this was, in his view, not a complicated fraud. It is a fraud which should have been detected in its infancy and could have been prevented if the state officials had been more diligent. He said among the state officials was a lawyer who knows the law. He knows that, for example, a company which is not registered in terms of the Companies and Other Business Entities Act has no capacity to act. Why did he allow this thing to sail through? He knows, for example, that the whole reason for submitting documents is so that they can be verified. Otherwise, there would be no point. We also add that these documents were crying out for verification. The documents themselves speak. They say, verify us through the code. Verify us through the verification code. Verify us through the Kira code. But it is a fact that verification, that due diligence was not undertaken. But the witnesses explained that the documents were so convincing that there was absolutely, it appeared that there was no need to verify them. They were used to dealing with these documents, and they looked exactly like the originals that they'd been dealing with all along. We understand the argument by Mr. Maduku, but we don't believe that it is a factor that we should really give much weight as mitigatory. There's everything to say about what went wrong for the ministry. But that is what fraud is all about. Fraud is all about deceiving. It's all about making things appear okay. And these are the ministry officials were convinced that these documents were. In the absence of such conduct, they would like this. There was nothing. We are aware that there are so many gate pickers. We are aware of interviews. Mr. Koto spoke about circumstances where people attend interviews for recruitment for employment, and we all know that usually certificates that are submitted are accepted at face value, as long as they don't look suspicious. Yes, the officials could have done more, but definitely that cannot be a factor which an accused person can rely on so much in mitigation. We are not saying gullible people. If your victims are gullible, then that reduces the moral blameworthiness of the perpetrator of a crime. We at least on this one, we do not agree with Mr. Matuku. He said we don't need to look at the prejudice because the state officials brought about this. I'm sure that argument is self-defeating because the accused person submitted these fake documents, with the belief that they would be accepted, and they were accepted. So there's no contribution. They were just deceived. Actually, ironically, while condemning the ministry officials for leaving, we are surprised that even the legal practitioners who represented the accused persons at this trial believed throughout the trial that black deck livestock and poultry farming is indeed a legal persona, and that this Black Deck Private Limited, it is the same as Black Deck Private Limited. I've already referred to the mitigation by Mr. Cotto, which he persisted with, even in circumstances where the state proved that Black Deck Livestock and Poultry Farming is a fictitious company. He is still laboring under that misrepresentation. He is still so affected by it that he argued forcefully that there was nothing wrong. He still argued forcefully in mitigation that a contract came into existence. So why blame the ministry officials for being gullible when we have got legal practitioners who are privy to all the circumstances of this case, who still believe that a contract came into existence? That's the extent to which this crime was sophisticated. It was so properly thought, it was so carefully thought out and so carefully executed that, in fact, at the ministry, they were so confused that they ended up describing the bidder by 4 different names. Some would refer to it as Black Deck Private Limited, others would refer to it as Black Deck Livestock, others would refer to it just as Black Deck. Some would refer to it as the person who drafted the contract referred to it as Black Deck Livestock. And that's how confusing, the method of operation was. And we therefore will not place much, weight on this submission that the fraud was not sophisticated. It was in fact sophisticated. The officers who testified on behalf of NASA and on behalf of Zimra said, these are employees of the organization board, said, by merely looking at these documents, they appeared perfectly normal, perfectly genuine. And they were only able to discover that they were counterfeits by scanning them. Other than that, they were perfect. And that's a sophisticated fraud in our view. So we can't really blame the state officials for being misled, because the documents used in this matter were carefully designed to mislead. The officer who gave evidence on behalf of NASA even went as far as saying it's difficult to tell how this was achieved, but all the same it was achieved. The official from Zimra said the same thing. It's difficult to say how this was achieved, but all this is. According to the official from Zimra, he said it is not possible for a Zimra tax clearance certificate to be issued to 2 companies. But somehow in this case, that appeared to be the case. In other words, that was made to appear to be the case, rather. How it was achieved, they've not been able to decrypt. That's how sophisticated this crime was. The state made submissions in rebuttal. To start with, they laid evidence on the impact of this crime. They called Alban Mindurwa to give evidence on this. A victim impact statement is described in the sentencing guidelines as a pre-sentencing statement made by the victim of a crime or other person, or presented to court the details of the physical, psychological, social, or financial consequence of the offense. To prove the financial consequence and the impact on the victims, the social impact, the state called Alban Mindurwa. He gave his evidence under oath, but essentially by reading from from a victim impact statement which he had prepared and signed before a commission of oaths. He gave the background, which we have already alluded to. He gave the justification as that the scheme was identified as a catalyst for rapid livelihoods and improvement through commercialization of goat production and food security, nutrition security, and to increase income, and therefore realizing the aspiration of government policy vision 2030 and NDS1, which he did not quite explain. In this long term, smallholders would contribute to the growth of the domestic and export market. And goat production is one of the key climate-proofed livestock production in the country. He outlined the target groups as disabled persons, child-headed families, elderly-headed households, widow-headed households, and chronically ill or orphaned households. He spoke about the targeted status of the people, and he then referred to what we have already referred to in terms of the performance of the tender. He said the program is essentially collapsed. So far, there's been no movement, and the implications of the suspension are that have impacted negatively on the intended role of vulnerable groups, and the collapse of this program has eroded public trust in government rural programs. They have tainted the image of the ministry and the government of Zimbabwe. They have affected the operational and budgetary already strained treasury. And he said the presidential flagship program has damaged the country's, the flopping of this presidential program has damaged the country's image. And either locally and internationally. We only need to add that it has also damaged the image of the head of state who was spearheading this program. He then went on to explain how it has affected the attainment of Vision 2030, and we don't need to explain, to go into that because it's already part of the written judgment. It's on record. The state then made submissions regarding the written guidelines and the application thereof to this case. The state alluded to what I have already referred to in terms of the presumptive penalty. The state acknowledged that ordinarily the sentencing guidelines require that where a fine is provided for, a court must start from that fine as a possible option, and only when it excludes the suitability of that fine as an appropriate sentence should it move to other non-custodial options like community service. But having said that, the state submitted that the gravity of this offense is such that a fine would not meet the circumstances, the justice of this case. A non-custodial sentence would also not do that, because this offense was premeditated and carefully planned, because it threw everybody off the scent, and he suggested that the starting point should be the 20 years imprisonment. He referred to the prejudice, which he said was high. He also cited cases, but which were relating to fraud. And in one case, the court, which is the case, in one case, which is the case of Catherine Chimombe, and another Harare High Court, 51 of 23, the court had this to say: fraud is a serious offense. Hence, the penalty ranges from a fine not exceeding level 14 to imprisonment not exceeding 35 years. And said, in refusing to set aside a prison sentence, said this particular offense was premeditated, complex, well-planned, and expertly executed. The state submitted that that was the situation in this particular case. The state referred us to another case which involved fraud in the amount of 10,000, and the accused person was sentenced to 10 years imprisonment. The state referred to the notorious case of Samson Mashata Paweni. We are still looking for the citation, but it is one case which occurred in the 1980s, and in our recollection, it would be the only case which, in terms of seriousness, was of as much as of the same, considered to be the most serious. But clearly, this offense before us, as far as all the information that we have at hand, is one of the most serious. Is the most serious case of fraud that the courts have had to deal with since independence, 45 years ago. As I've said, I will now relate to the principles that guide sentence in the guiding guidelines in arriving now in determining the sentence that should apply to this case. The sentencing guidelines are mandatory. We are required to take into account the objectives of sentencing, which are to rehabilitate, punish the offender to the extent in a manner which is just and proportionate. And all sentences must take into account one or more of the following: reformation, that is to assist offenders to rehabilitate. Mr. Mgia submitted this, and we agree that reformation, rehabilitation is critical in this case. It's also achieved by suspending a portion of the sentence. It's also appreciated by shortening any prison sentence so that the accused persons are not exposed for too long to hardcore criminals. Retribution has come back as consideration in sentencing. Retribution is described as ensuring that the offender should face a sentence that is equal in measure to the harm he or she has caused. What this simply captures is public revulsion. This is the reason why, where the offense involves public funds, members of the public, citizens in general, expect a sentence which clearly shows its disapproval of abuse of public funds. And this presumptive penalty of 20 years is one of the most severe presumptive penalties in the schedule of presumptive penalties. And that clearly is informed by the expectation of society that people who abuse public funds should be punished. A court, we agree with the state, would be failing if it doesn't recognize the expectation of society. Deterrence is, Mr. Mgia referred to this, is there any possibility of reoffending? Perhaps with respect to the accused persons, yes, they are, in their middle ages, and there is no likelihood that after this experience they may reoffend. That's a very forceful submission. But deterrence does not only relate to the accused persons, it also relates to society at large. Like-minded people should be deterred by the sentence that we are going to impose. And that of course relates as well to protection and prevention. Restitution is a very serious consideration. That is why it is given weight. So clearly, courts normally apply this or give this effect by suspending portions of that. That is also captured in the sentencing guidelines themselves. So all sentences must be proportional to the offense. They must be consistent, which is why we have this, the presumptive penalty. We have already taken into account the aggravating factors that are listed in the table in determining the presumptive penalty. But there are general provisions relating to aggravating factors and mitigating factors. These are the circumstances that we then take into account in considering whether to go above or below the presumptive penalty. Mr. Maduku took us through this. The State Council also took us through this. We agree. They are correct. That is how a proper sentence should be arrived at. Those that are considered as aggravating circumstances include, in this case, that benefit the accused persons are previous convictions, they are first offenders. Rather, I will repeat that. With respect to aggravation as submitted by the state, the accused persons are not repeat offenders, they are first offenders, so to that extent, they are not affected by that aggravating factor. Evidence of prior planning and premeditation, I have dwelt at length to the manner in which this offense was committed. That was careful planning. The offense was organized crime. Well, yes, because they are co-perpetrators to that extent. They acted as an organized gang. Whether the offender targeted or prejudiced a vulnerable victim, this is what the state was at pains to explain, that they deprived the poorest of the poor. This is what the Mr. Mindurwa, who gave evidence on the victim impact, was at pains. So this aggravating feature is present. And where the offense was committed with repeated and gratuitous law, this does not apply. Where the offender abused their position of power, authority or trust, is broader now, is position of power. The second accused person said he is a member of the Central Committee of the ruling party. He said he's the chairperson of the EEG, which advocates for, which lobbies for local companies. We said in our judgment that is a legitimate cause, but it must not be abused. It had no place in this case. He had no reason to even assert in this court that he attended a meeting concerning a performance of a government tender, wherein his position of power as chairperson of a political pressure group. That is completely misplaced. That's abuse of power. Whether the accused played a leading and significant role in this plan, we have already said the first accused person played a significant and leading role in the commission of this offense. He said when I heard of this contract, I decided that this was an opportunity. I decided that we should submit a bid. I decided that the name Black Tech Livestock, I'm saying I because he said he was part of that decision as part of the board to submit the bid in the name of Black Tech Livestock and Poultry. He clearly played a leading role in attending all those meetings, in negotiating the prices, in purporting to perform. He even cancelled what he believed was the contract. He was clearly in charge of this. He played a leading role. His involvement was clearly aggravated. These aggravating circumstances would therefore persuade us to go above the presumptive penalty of 20 years. However, before we do that, we must now consider the mitigating circumstances submitted by Mr. Matuku. He argued forcefully, and I repeat, that there may be co-perpetrators, they may have been found guilty as co-perpetrators, but their roles are glaringly different and the second accused person must benefit from a lesser role. We have said we accept that submission. Clearly, the sentencing guidelines themselves direct us to take that into account. But the other mitigating circumstances, as listed in the sentencing guidelines in Section 9 of the sentencing guidelines, are missing. The only other mitigating factor is that the second accused person is the first offender, or that both of them. But then, they did not readily admit, so they can't benefit from that. They have not shown any genuine remorse. I've said we'll let the first accused benefit from the apology, but somehow, Mr. Court on his behalf continued to submit forcibly that there is no correlation, there's no relationship between the fraud and the prejudice. In any event, it's neither here nor there. Some people get employment as teachers using fraudulent qualifications. So, as far as is concerned, qualifying for a contract, a government contract using false qualifications, is not really anything serious. We believe that he was speaking on instructions, and if those are the instructions, there's no genuine remorse in that. In fact, the accused person started off by saying that on behalf of Black Deck and as a director, he apologizes until the prosecutor, reminded him that he was appearing in his personal capacity. That's when he apologized. So the remorse, yes, he will benefit, but it's not really as genuine as it ought to have been. Well, the second accused person benefits, as far as I'm saying. Likelihood of reoffending, that has been referred to. Evidence, the second accused person offered to restitute, and if ordered to do so by the court, obviously that is an intention to restitute. Having said that, we find that there may be need to distinguish between the accused persons in the sentence that we are going to impose. The second accused person submitted at length in mitigation in the normal way. But the first accused person, whether it's his lawyer or his instructions, was clearly intransigent. But the second accused person, we were persuaded, by the seriousness of the mitigation. The weight to be attached to it is another. But we could feel that this was mitigation well motivated in terms of the principles that are applied to mitigation. So we also recognize that in terms of distribution of the proceeds, the state managed to prove that the second accused person got 200 million ZIG then, which we have converted to United States dollars at the time, and that has been the proven, his proven benefit. He may have benefited more, but as courts, we always give benefit of the doubt where issues are not clear. So there may be need to distinguish between the accused persons, and we did distinguish between them. I've already referred to the fines and so on. I've referred to the personal circumstances. The second accused person, as I said, submitted, in the usual way, genuinely. He was prepared to take this court into his confidence about his personal health. And, once that has been done, the court must take that into account. We are unaware of any health complications with regards to the first accused person. The state submitted that a sentence of 35 years imprisonment would meet the justice of this case. They suggested that this court could temper justice with mercy by suspending 5 years on the usual conditions of behavior, and 5 years, of that remainder, 5 years on condition of restitution, leaving an effective penalty of 20 years. We understand where the state is coming from. Over a period of 45 years, this is the most serious case that the courts, at least to the extent that we are aware, that these courts have dealt with. We understand that abuse of funds has become a major concern, and corruption is a major concern. I say corruption, although we are not dealing here with an offense called corruption, but if one pays regard to the standard bidding document, it actually mentioned that there should be no corrupt practices. And corrupt practices were then defined that the ministry, the companies were expected to be ethical in their conduct, in either securing the contract and in performing it. So clearly, unethical behavior is under the umbrella of corruption, particularly if it involves public funds. And there are several programs now that have been embarked on by the government to fight corruption, and so clearly there must be a deliberate shift towards imposing deterrent sentences when it comes to cases of this nature, cases involving platform, to deter. So we understand that's where the state, the state is coming from. We, however, accept that jurisprudence has shown us that the maximum penalty provided is always reserved for the most serious offences. What jurisprudence tells us is that it's possible that the worst of fraudsters have not been born, so they'll probably be here in future, and we must reserve the maximum penalty to deal with such more serious offenders. Nobody thought that we would have a case of more serious than the Pawan case, but here we are. So jurisprudence tells us that more serious cases may still come. So we will abstain from imposing the maximum penalty. We also believe that the maximum penalty should also be reserved for repeat offenders. The accused persons here are first offenders, and it would be inappropriate to impose the maximum penalty on first offenders. That would breach the other values or purpose of sentencing, which I have already referred to. We have already referred to the mitigating circumstances. With respect to the first accused person, we find that the aggravating factors, the circumstances of his involvement in this crime, are aggravated, and the aggravating factors, the general aggravating factors in Section 9 of the sentencing guidelines, outweigh the mitigating circumstances, which is a reason for us to move above the presumptive penalty of 20 years. With regards to the second accused person, I have already said what we think about him, with regards to the mitigation that was made on his behalf, and we believe that there's justification to go below the presumptive penalty. There's also, as I've said, restitution where it has not been voluntarily made can still be made through an order, through some form of coercion. The sentencing guidelines tell us that a court that is pursuant to the provisions of the Criminal Procedure and Evidence Act, a court is empowered to suspend a portion of the sentence on any conditions that it deems fit. It may be one, it may be two, it may be more. In this case, we find a sound legal basis for suspending the sentence that we are going to impose on the accused persons, or the sentences that we are going to impose on the accused persons. Firstly, on condition of good behavior, because that's a way of deterring them, that's a way of rehabilitating them. When a sentence is suspended, it hovers above the head of the offender, and for a period of suspension, deterring him from repeating the offense. we aim to achieve that by suspending a portion of the sentence. It is up to us, and we have, in the exercise of discretion, considered that we should also submit a portion of the remainder of the sentence after the sentence is suspended on condition of restitution. Now, we then had to consider the rest, what we would order as restitution to be paid by the accused persons in suspending portions of sentences. The practice of this courts, their case law, which appear in the judgment, is that the court must apportion the responsibility, the duty to restitute amongst the persons charged with the offense or convicted with the offense. Not charged, convicted of the offense. That's the normal trend. So where $10 is the prejudice, each should contribute $5 each. Each should contribute $5. It has been found to be an equitable way. Not saying one should pay the other to be absolved. It's a bit difficult. So we are going to adopt that approach. But ordinarily, as I have said, the court normally looks at the number of the people that have been convicted of the offense and then apportions the responsibility to restitute based on the number. That is dividing the actual prejudice by the number of people that have been convicted, as I've illustrated earlier on. This is a unique case where the court is dealing with two accused persons. But in the evidence, it became clear that there were other offenders who were liable to be charged with the offense. We don't, we are now aware of Chimombe. We are now aware of Black Tech Private Limited. We are now aware of Ajune Kabisela. They are liable. They are not before us. They have not been convicted. So ordinarily, we would not be apportioning any duty. We can't, in fact, apportion any. We cannot, lawfully apportion any duty to restitute to them because they are not guilty. They are presumed to be innocent. They are, in fact, innocent because they've not been charged. But we can't really not take into account that the facts in this matter point to their involvement and obviously possible benefits in this crime. Whether they're going to be charged is a different issue. But we decided now that in the exercise of our discretion, we can properly take that into account. And we will take that into account. I must emphasize, I'm not saying they are guilty, but I'm saying the facts before us point to their involvement. The accused persons have been convicted as core perpetrators, and the evidence points to other core perpetrators who are not before us. We must take that into account, and we will obviously, in apportioning restitution, take that into account. If we are wrong, we don't regret that, because courts must always err on the side of leniency. That is the jurisprudence that we have. With respect to overall punishment, as I've said, we start from the premise that they are all liable to a similar penalty. Then we deal with each individual. We had considered that a sentence of 25 years imprisonment would meet the justice of this case. But we take into account that the accused persons have been in custody for 18 months. And that period, when translates to 27 months, if one takes into account the usual remission that serving people are allowed in prison for good behavior. We accept the submission by the state that the accused persons were by and large responsible for the delay in completing this case. We say so particularly with reference to the first accused person. The judgment is very clear that at the end of the day, the first accused person admitted all that he was denying in this defense outline, which led me to ask Mr. Koto whether this trial was worth it, at least with respect to his client. We even went as far as say this the first accused person trial could have proceeded on the basis of a statement of agreed facts, because his involvement was eventually admitted by him. There was no reason for him to, spoil this trial, call people names, attack the court, attack assessors, attack other people who may not be part of this trial, instead of concentrating on the offense that he was charged with. He clearly was to blame. But having accepted that submission, we still feel that he was in prison all the same. It was self-inflicted incarceration. In the process, he has been in prison for equivalent of 27 months because of his conduct. But we must take that into account. We will. Yes. It's not really that strong, but we as a court, it's also the same incarceration. So we gave them a discount for that from the 25 years. And the second accused person, while we are not very sympathetic with the first, the second accused person must benefit from the fact that he's physically ill. Having said that, the accused persons will be sentenced as follows. The first accused person is sentenced to imprisonment for 22 years, of which 3 years are suspended for 5 years on condition the accused does not, during the period of suspension, commit any offense involving dishonesty, for which upon conviction he is sentenced to imprisonment without the option of a fine. Of the remaining 19 years, 4 years are suspended on condition the accused person pays restitution in the sum of United States I would have to I will revert to the amount of restitution later because the figure here is not very clear. But I must say the figure was arrived at as follows. We first of all deducted what we believe the second accused person benefited through Militech Enterprises. We then considered that 3 accused persons remained, who are the first accused, Black Tech, not quite accused persons, but people who were liable. The first accused, Black Tech Private Limited, Black Tech Private Limited, Ajine Kabisira, and Tinashe Chimombe, and then we divided that, his benefit by 3, and we ordered him to restitute that. So that is their figure that he must restitute as a condition of the 4 years that we suspended on condition of restitution. So the actual figure is literally that figure which will appear in the judgment, and we have suspended 4 years for that purpose. That leaves an effective imprisonment of 15 years for the first accused person. I have already indicated that with respect to the second accused person, we are persuaded that there is a sound basis to go below the presumptive penalty. He is sentenced to imprisonment for 17 years, of which 3 years are suspended on condition, are suspended for 5 years on condition that during the period of suspension, he does not commit any offense involving dishonesty, for which, upon conviction, he is sentenced to imprisonment without the option of a fine. A further, out of the, of the remaining sentence of 14 years, 2 years are suspended on condition that he pays restitution through the registrar of this court. I have already indicated that we will give him that benefit in terms of lesser benefit. What has been proved to have gone through the account of Militech is what we are going to order him to restitute. We have converted that to United States dollars at the time. It converted to 964,024 United States dollars and 64 cents. This is the amount that he must restitute through the registrar in order for him not to serve the 2 years that we have suspended on condition of restitution. That leaves him with an effective sentence of 12 years, hoping that my calculation is correct. They say lawyers are very bad at figures, but I hope I got them right this time. The order, the full amount, the actual amount of restitution to be made by the first accused person will appear in the order, which will be uploaded on the because it's a bit not clear, it's smudged on the document that I'm reading. So there should be no prejudice to that. I hand down that sentence.
As the court pleases.
Any other business?
Yes, indeed, my lord. Yes, my lord, our instructions are to proceed in terms of Rule 94, Sub-Rule 1A of the Rules of this Honorable Court, in respect of which, in part, my lord, my instructions are to apply for leave to appeal against part.
Wait a second. I'm looking. Oh. This one. This one is full. But maybe just before you proceed, Mr. Jetero.
Yes, my lord.
We are aware of the accused person's right to make an oral submission for you. I'm sure it's leave to appeal.
Indeed, my lord.
What does he want to appeal against? Conviction and sentence?
Yes, my lord. Part of his grounds of appeal, some are against, they are all both against conviction and sentence, but some of the grounds of appeal are only in respect of the findings in law, and some of the grounds are in respect of findings of both law and fact, and then some against findings in fact.
Okay, thank you.
Yes, my lord.
Let me hear from Mr. Matuku.
My lord and lady, we have a similar instruction,
Yes.
and we are in the same position, but for us more, it's a mixture of law and facts, so we need leave. But we are appealing against both conviction and sentence.
Yes. Okay. Very well. As I was saying, I'm aware that in terms of the rules, offenders or convicted persons are allowed to make oral application for leave to appeal in an appropriate case. As you say, this is an appropriate case where such leave is required, and which right must be respected. I'm also aware that if that application is not made, it can still be made in writing within the period stated in Rule, is it Rule 94?
In terms of Rule 94, Sub-Rule 2.
Yes, of the High Court rules.
Yes, my lord.
My direction is that the convicted accused persons should submit their application in writing within the time frame that is stated in the rules, and the state will also respond in writing.
As the court pleases, we do take note, my lord, that in terms of the Sub-Rule 2, though, it would then require an additional requirement of an explanation of why the application was not made immediately after the decision had been pronounced.
Yes, because the court has directed that.
Yes, indeed.
Yes,
that is the explanation.
So you actually have, I actually have allowed that the application be made in writing. So you won't, you probably need only state that.
Indeed, my lord.
That was the direction of the court.
Indeed, my lord.
Yes. So yes, but it has to be within
the 12-day period.
You know that as the rule proceeds, it says if you don't make it within is it 12 or 14 days? I'm not sure.
12 days, my lord.
12 days.
Yes, my lord.
Then after that, you need condonation.
Yes,
I'm
my lord.
hoping that it doesn't get to that extent.
Aye.
I'm actually directing the parties to make their application writing within the time frame that is stated in the rules, which is we all know to be 12 days.
Indeed, my lord, we do take note of that. Maybe that then just on the occasion of the first accused person, maybe it just leaves us with one housekeeping issue relating to the judgment, my lord. We do take note that there was another judgment that was uploaded on the 4th of December, which was a correction of the one that was uploaded on the 1st of December. Yes, my lord. And that there is an extempore judgment of the Honorable Court on the 22nd of November 2022. I just wanted to seek clarity from the Honorable Court in respect of the date
I'm sure we all know that the extempore judgment was given in terms of the Criminal Procedure and Evidence Act, which requires all judgments in criminal matters to be read out in an open court.
Indeed.
It is also the practice of this court that after an extempore judgment, the court may then produce a judgment for circulation, which is always the version that the parties should really work with, because an extempore judgment contains some slips, and so on. So the actual judgment for circulation is the judgment which normally work with. But there is a corrigentum which is attached, unless you missed it.
Indeed, we had it, my lord.
Which was uploaded with the judgment, which you say was uploaded.
On
it was
the
just
4th, yes.
to correct typographical errors. And I think that is in accordance with practice in these courts. It was not really like to change the ratio of the judgment, but just to correct typographical errors. You can imagine that judgment was uploaded under pressure. The accused persons were placing the court on terms, which is very unusual, but it happened. But after producing that judgment, after reading it, I realized that there were so many obvious patent errors. These are harmless errors, which would not have needed the judgment to change, but they are so annoying to the reader that we just needed to clean those typographical errors. So the judgment, if you look at it, is essentially the same.
I'm indebted to that clarification, my lord.
My lord, for the second accused, we confirm that we'll take the direction of the court that we put our application in writing. But we have one additional request which we would want to place on record. This request relates, the reason why we had preferred an oral application is that the decisions tend to be faster in getting, because our clients are very much intent on ensuring that perhaps before Christmas we have filed papers before the Supreme Court. So what I know, and I say so with due respect, is that if you are inclined to grant us leave to appeal after we have filed our documents, perhaps the court can simply give an order without
on the papers.
Yes, on the papers. If that is, if we are granting
I'm inclined to adopt that approach, but if for some reason after reading the papers I require assistance, I will immediately convene the court. It does not necessarily have to be like this. This is a matter of law. It's a matter that I can quickly convene in the usual way, and then the lawyers appear to motivate. That is if I really need to be assisted. But if the submissions are clear, yes, we'll be quick and determine the application papers.
Yes, so we are saying so, my lord, if I may interrupt, because I see that my learned friend is now already pulling his microphone. I don't know what he wants. But we think that in such a matter as this one, given the length of the trial, the complexities, you said in your sentencing judgment is one such thing that normally we would get leave to appeal unless we make a hopeless case. And we intend to really make a persuasive presentation. And we will try and prevail on our colleague if he could be of assistance to the court that perhaps leave to appeal be granted. That's all I wanted to say.
Yes. I'm sure he's pulling his mic because he expected to be asked to be given an opportunity to speak before, and that was an oversight on my part. You can still say what you wanted to say.
Yes, indeed, my lord. The state will also take advantage of the 12-day window period to consider the issue of sentence. The Prosecutor General might want to have a look at it as well.
Yes. Very well. So there will obviously be application in count. There's a possibility of a counter application by the state for.
That is a possibility which is quite strong,
yes,
my lord.
Yeah, that's for that stronger reason. We should maintain that submissions should be in writing. Parties need time to reflect carefully.
With your leave, in the event that that is the position they take, then we should somewhat, by consent, that there would be an appeal. They have their counter appeal against sentence. We have our appeals against both conviction and sentence. I'm just putting it before you in the event when you get our papers, we still persuade the court that if they are adopting that addition, then this is a proper case for leave to appeal.
Yes. The parties have not made any submissions regarding time to pay restitution. Is it the intention to pay straight away?
Oh, well, my lord, we had not consulted on that, my lord. I wanted to suggest another course of action may be different from what my colleagues are suggesting, my lord. Given that ordinarily we know that we are during the vacation period, if my colleagues are with me, what I wanted to suggest was that we could undertake, my lord, given the agency of the matter, to file whatever papers that we need to file within a curtailed period, given that the rules allow for this application to be done immediately after or within 12 days, and his lordship has directed that we file it after. I wanted to suggest that maybe if we are given maybe 2 days or 3 days to file our application, maybe the state can be given also another period, and then we set the matter down on a given date so that we then dispose of this matter, rather than to just leave it out in the open, that if we file in 12 days, my experience is that it may then take a bit of a longer time for then the matter to be then disposed. That was my suggested course of action.
Leave to appeal, my lord, is not an urgent application by nature. I think if my learned colleagues file their applications, then the state will file its response in terms of the rules, without the court having to give time frames.
Yes.
So if the application is in terms of sub rule 94(1) B, then I think my colleagues would file their applications, and then the state will do the same. Should the Prosecutor General decide to make any cross appeal, that will be seen during that period on what will then transpire.
Yes, thank you. I don't need to rule on this because the rules speak for themselves. The rules provide for this written up and the time frame within which the Prosecutor General should respond, and the time frame within which the registrar must place the application before the judge, presiding judge. All that is there. I don't need to rule on that. Let's just stick to the rules. I see the Rule 94, Sub Rule 2, providing for the written application, and then sub-rule 3, providing for service on the Prosecutor General, and that the Prosecutor General may respond by way of filing submission within the period stated therein. Then I see sub-rule 4, regulating or rather compelling the registrar to place the written application or the whole case thereafter before a judge in chambers. All that is there, which, like as Mr. Maduku submitted, that it can be considered on the papers. Chamber applications are normally can properly be considered on the papers, although we know that when judges require assistance in chamber matters, they can call the parties to assist. All that is provided for. There's nothing really, for me. And the rule, the rule 94 also provides for a situation where the Prosecutor General intends to apply for leave to appeal. All that is there. So the law provides for all this. The parties will be guided by the operation of the law in the regulations. There being no submissions regarding time to pay restitution, the order will show that the restitution must be paid no later than 28th February 2026. Any other business?
No further business, my lord.
Cora Jones?
Mr. Mabaud.
Che. Nani?
Mukundigno. Mukuya give us a sentence. Okay, we drive. I'm going to go to the